Welcome back to The Explainer. Today we're jumping straight into a topic that's absolutely fascinating but incredibly complex, the U visa. If you follow immigration policy, you already know the landscape has shifted pretty dramatically by 2026. So we're going to unpack the current state of the system, answer the core question of what's the U visa in simple terms, and take a hard look at the reality of applying for one today.
Here is our quick roadmap for today. We'll cover 1. What is a U visa? 2. Who exactly qualifies? 3. The path to approval. 4. The 2026 backlog crisis. And finally, 5. Surviving the long wait. Let's get right into it.
Section 1. What is a U visa?
So tackling our main question, what's a U visa in simple terms? Well, think of it as a humanitarian lifeline. It was specifically designed to protect vulnerable people who have suffered severe trauma. Basically, it acts as a temporary, non-immigrant status that allows non-citizen crime victims, and sometimes their immediate family members, to step out of the shadows. It lets them live legally in the United States and obtain authorization to work. Ultimately, it was created to ensure that fear of deportation doesn't stop someone from reporting a crime.
The whole idea behind it, the original promise from way back in the year 2000, was crystal clear. Protect victims so they can actually help police catch criminals without constantly looking over their shoulders, terrified of deportation. It's meant to be a mutual benefit, right? Law enforcement gets the critical witness testimony they desperately need to prosecute dangerous offenders, and the undocumented victim gets a safe harbor.
Section 2. Who exactly qualifies?
Now, simply experiencing a crime isn't automatically going to get you a U visa. There is a very strict set of criteria here. The requirements really rest on 4 main pillars. First, the crime has to be on a specific qualifying list, things like human trafficking, domestic violence, or felonious assaults. Second, the applicant must have documented substantial physical or mental abuse. Third, the victim actually needs to have useful information about the crime. And fourth, and this is literally the absolute anchor of the whole U visa, the applicant must be helpful to the police, prosecutors, or judges. If law enforcement refuses to officially certify that helpfulness, the application stops dead in its tracks.
Moving right along, Section 3, the path to approval.
So how does this work in practice? It's a very long, heavily procedural journey. Step 1 requires getting that law enforcement certification we just talked about. That's Form I-918 Supplement B. Step 2 is submitting the massive application packet to U.S. Citizenship and Immigration Services, or USCIS. Step 3 is a preliminary review called a bona fide determination, which basically checks if the case looks genuine enough to offer some interim relief. Step 4, you're placed on the official waitlist. And finally, Step 5 is the ultimate goal, final adjudication and the actual granting of the U visa.
Which brings us to Section 4. The 2026 backlog crisis.
This is where the original promise of the law completely slams into the friction of modern bureaucracy. The systemic bottleneck is just incredibly severe. The law literally only allows for 10,000 principal approvals a year. That's a hard cap set over 2 decades ago that has never been changed. But consider this, in fiscal year 2025 alone, USCIS received over 67,500 new petitions. I mean, you don't need a math degree to see the structural impossibility there, right? Because of that static cap, the backlog of pending petitions has absolutely skyrocketed to over 400,000. That massive number includes both the principal applicants and their derivative family members. Just think about what that means for someone's timeline. The supply and demand are so severely mismatched that we aren't talking about a few months of waiting anymore. We are talking about waiting periods that span a significant portion of a person's entire life.
To make matters even more complicated, there was a landmark shift in February 2026 known as the matter of Ibarra-Vega. Basically, immigration judges can no longer indefinitely pause deportation proceedings just because a U visa is pending. It used to be that if a victim was in deportation proceedings, a judge could essentially freeze the case using something called administrative closure until the visa was ready. But this new ruling states that a pause is presumptively unreasonable if it exceeds 6 months. And since we just established that the waitlist is over 400,000 people deep, a 6-month pause is literally a drop in the bucket. It creates immense legal tension for applicants who are doing everything right by cooperating with police, but are still facing active removal.
And that leads us to our final section. Section 5, Surviving the Long Wait.
So, with final approvals potentially taking decades, how do people actually survive the waiting room? Well, the primary survival tool is the BFD, or bona fide determination. Because the wait is so absurdly long, USCIS does this interim review. If your application looks complete, you've got the police certification, and you pass a background check, the government can grant you deferred action. Now, this doesn't mean your U visa is approved, but it means they won't prioritize deporting you.
And crucially, they can issue you an Employment Authorization Document, or EAD, so you can legally work and support yourself.
But let's be real, the timeline is still pretty grim. As of 2026, it takes roughly 35 months from the day you file just to get that interim BFD review. That is almost 3 full years with zero legal work authorization and no formal protection. And from there, looking at current backlogs, final visa adjudication could stretch anywhere from 10 to 20 years down the line.
And there's another massive financial hurdle. Due to 2026 regulatory shifts under the H.R. 1 Act, work permit validity dropped from 5 years down to just 18 months. Since the wait for the actual visa is so incredibly long, applicants are caught in this endless cycle of rolling renewals. For a family of 4, renewing every 18 months with the new non-waivable fees means shelling out over $10,000 over a 9-year period just to maintain the right to work while they stand in line.
Does a system defined by decades-long waitlists and shrinking work authorizations still serve its original humanitarian purpose? When we asked earlier, what's the U visa in simple terms, the answer was a lifeline for victims bravely helping law enforcement. But today, faced with a 400,000-person backlog, 3-year waits just for temporary relief, and the crushing financial drain of rolling renewals, is this framework really functioning as intended?